Hello everyone, and welcome. I'm very happy and excited to present to this group, and really looking forward to hearing some of your thoughts and comments later. And I would admit that I think an hour is not such a long time, so I'm hoping to leave enough time for discussion. So today I want to talk about therapeutic jurisprudence and how I think it's very relevant in the context of the Israeli District Psychiatric Committees. So maybe just to give a sense of why I think it's really an important topic and how I connect to it. So I would say that my personal background that relates to that, I guess, began with my appointment as a chair of a psychiatric committee. And during the time that I was doing this semi-judicial role, over the past, I guess, 4 years or so, I took part in discussions and meetings with about 2,000 patients so far in involuntary hospitalization, and the decision-making process that relates to whether or not they should be kept in hospitalization, should they be hospitalized against their will in a coercive measure, or otherwise receive coercive treatment. And I think that the effective kind of influence of that, the emotions that it stirred in me, and a lot of the processes that we had during the day and at the end of it, when I was thinking about what I've seen and the stories that I've met, led me to think that this is something of unique importance, and more than just cognitively, it's really emotionally one of the most unique experiences I've ever took part in, and the most meaningful ones. And today I will try to speak both in this capacity from my own experience, but also as an academic. So as a member of the Faculty of Medicine in Tel Aviv University, as the nursing department. So we have already published one paper on the topic and several other publications, and I would like to connect the theoretical and the practical. And I'm so happy that we have one of the leaders of thought in the field, Professor David Wexler, joining us here. So I'll be happy to get his input later as well. And so let us begin. So I will focus on civil psychiatric treatment order in the context of the Israeli law. So if, according to the law, if a person is with what we define as mental illness, which is usually understood legally in this context as being in a psychotic state, then if, due to being in such a state, due to the mental illness, there is also significant impairment in one's reality testing. For instance, if somebody is, talking to demons and is sure that they're the Messiah and that the CIA is chasing them and so on, it might be related to impairment in their reality testing. Obviously, it could also be true. Or their judgment, which could usually be seen by the acts that they do. If that leads to some kind of dangerousness that is defined in the law, this might be legal reason to allow for coercive measures, including coercive treatment in psychiatry, and even coercive measures such as involuntary commitment. Now, I would say that dangerousness is the most legal part of that chain of things that need to be fulfilled if you want to make the decision, because mental illness may be more of a psychiatric, not a term, but it's psychiatrically decided. You need to see whether there's psychosis or not. And impairment in reality testing or judgment is also something that the clinicians might be very good at doing. But the concept of dangerousness is really not necessarily just a clinical decision, but it's really a socially based and also a legal decision. And the law in Israel talks about any of the following, let's say, 5 reasons that could be seen as enough dangerousness to sometimes justify coercive treatment if somebody's mentally ill and with significant impairment. So if someone's ability to take care of their basic needs, for instance, is severely flawed, that's one reason. And you can read the list here. Let me give you some examples from some of the cases and some of the people that I've met over the years. So let's say somebody's home is really, really dirty, and there's a lot of garbage thrown everywhere, and the food is rotten, and there's some rats running there, and cockroaches, and so on. At which point would that be considered, flawed ability to take care of their basic needs? And the food is rotten, and they're not buying any new food and whatever, and they're eating from the garbage of their neighbors. So at some point that might be enough to say this is, severe flaw in their ability to take care of their basic needs. As you can see, it's not really well defined. So you can argue that not every time that's a good enough reason for hospitalization, for sure. Other examples just from a few days ago. So somebody has some dogs in their home, maybe 6 dogs, in this case, 20 dogs. I love dogs. Not everybody who holds dogs, even if they're barking, will be hospitalized. But in this case, there were complaints that the dogs are, barking and they're like in horrible conditions. Usually it comes with other things, to the extent that it was seen that that woman was not able to kind of take care not only on her dogs, but other people as well. So might that be considered, let's say, severe mental harm to others? People are suffering so much from the dogs barking, that person yelling at them or whatever. Is that a good enough reason to say that their ordinary life is interfered to the extent that justifies compulsory treatment and hospitalization? Again, assuming that this is due to the mental illness and the severe impairment of reality testing or one's judgment, right? So these are just examples that we need to see and to think about. And there are many, many more. Somebody screaming at their home, screaming at people. Maybe they think that these people are against them, and so on, or hearing music late at night. Would that be considered severe, let's say, interference with the ordinary life of others, and so on? There's also reasons for hospitalization could be causing severe damage to property. And again, it says severe. So what should be counting as severe, damage to property? If somebody is drilling holes in the walls, is that severe damage? If they do that and also pee to the other apartment through those holes, true story. So it's not just severe damage to property, that's also kind of interfering with the life, the ordinary life, and so on, right? So you can see that a lot of times it will be a combination of those 5. It's not really just one of them. Usually it would be some of them coming together, but according to the law, at least one of them needs to be fulfilled, but it needs to be severe, or it needs to be danger. It needs to be something strong. Not every harmful thing that somebody's doing is enough to say that this is the level of dangerousness that warrants the decision of involuntary treatment. So some more examples would relate to, it could be danger to self or others. So let's say non-immediate physical danger to self. So if somebody's walking naked in the sun, is that severe is that non-immediate physical danger? Well, if they're doing it for several days, they're full of sunburns. At some points, they're starting to have inflammations and other things due to their neglect. It might, be that. It might be non-immediate physical danger. If they're almost naked in the snow of Jerusalem in the midst of the winter, and they're lying in the street and so on, at some point it might become non-immediate physical danger or even immediate danger when they're very much neglectful to themselves, right? Somebody on their balcony, on the ledge, maybe wanting to jump. That seems like immediate physical danger. Now, all I'm saying here could be true or not, because this concept of dangerousness is the one thing that the lawyers in our committees would work hard to say, do you have any proof that he was really trying to jump? For instance, maybe he was just looking out because he saw that the EMT people were coming. He wanted to say hello. He didn't want to jump, right? So that's really kind of a factual thing that we need to kind of see if there is any proof of that or not. Maybe get the police report, maybe get the EMT report and so on to kind of see whether or not there is evidence and factual grounds to those claims of dangerousness that we are needing to decide on when we make such decisions. And obviously, if somebody is holding a knife it might be dangerous to self or others, depending on the circumstances. If they're threatening to kill somebody else, that seems to be immediate danger, right? If they're trying to cut their throat, that seems very dangerous. But then they would say, look, it was really just symbolic. It was really just something with plastic. I didn't really cut my throat. I was just trying to scare my parents. I mean, that's not something you need to be so excited about, and so on. So as you can see, the decision-making here is interesting. It's a challenge, and you know, people who deal with these kind of matters, they kind of know that each story is unique in its own way, and decisions here are not necessarily decisions that you cannot debate over, especially in the gray area where it's not clear that it has to be, you know, such dangerousness that requires hospitalization, for instance. Now, having said, what about people who eat very little and so on? So, you know, these are questions I'm going to refer to later. Now, making those decisions, who does that when we talk about civil commitment in Israel? So let's see how it looks in the Israeli context. So every year we have about 6,400 commitment orders that the district psychiatrist issues. It means that when they receive information, the district psychiatrist, we have 5 or 6 of them in different districts, and they need to make the decision whether or not a person fulfills the legal requirement for involuntary commitment. This has to be based on a psychiatric examination, of course, and if they think that the person does fulfill those requirements, they would make the decision and have the order issued. If it's considered immediate danger, then the person would be immediately or would be brought to hospitalization and then could appeal to the District Psychiatric Committee. If it's a non-urgent case, then the person would be notified of their right to appeal, and they would arrive at the committee without being first hospitalized. And in this case, we would meet the person. If there is good enough reason to hospitalize them, then we will make the decision on the spot, and they will be hospitalized after meeting with us. Now, there are about 6,000 decisions a year about hospitalization, but about 14,000 cases discussed every year in the committee, because a person could be brought to the committee on average about 2.5 times for every time they're hospitalized. They could be brought immediately after hospitalization, and then a week later, and then maybe a week later for prolongation. And so on average, that's the number. And others will not arrive to the committee even once because they'll be released before they appeal, or they'll just decide that they want to be hospitalized, and their legal status will change from involuntary to voluntary commitment. That could also happen. So after the District Psychiatric Committee discusses, it's important to see that we have 3 members in the committee. So the initial decision will be made by a psychiatrist, but the appeal committee is consisted of 3 members. 2 of them are psychiatrists, right? And the chair of the committee is equivalent to a magistrate's court judge. So it's really a semi-judicial committee with 3 members. The chair is similar to a judge, and the other members are medical experts. And the committee's decisions could be also subject to appeal, and the appeal would be to the district court with 1 judge, no psychiatrist there. And while we discuss about 14,000 cases a year, a very small portion of them are arriving on appeal to the district court based on legal chances. So really, as you can understand, especially if the decision is made very close to the initial decision of hospitalization, chances are that nothing has changed dramatically since the order was given, although in rare cases, it could be that the order was given based on false information, which we could find on the first chance where we try to get more data and see that things were not understood so well. And also the decision of the district court could be reaching an appeal to the Supreme Court. It could be 1 judge or 3 judges, it depends. And in this case, we have around 6 cases like that a year. So it's really rare to have the Supreme Court even discussing those matters and kind of providing us with judicial guidance that is equivalent to a law in this field. So again, what can I tell you about the committees? First, I'm going to focus on the adult district psychiatric committees, although I do preside in the committees for children and adolescents, and it's a really a very hard touching kind of cases, but I'm not going to talk about that. It's a different setting, and I think it deserves a separate discussion. So we're talking about a semi-judicial or quasi-judicial tribunal. It's important to know that we operate based on the Commission of Inquiry law, which means that unlike a regular court, we have authorities of inquiry. It makes more sense to ask questions, to kind of step aside from the regular adversarial concept of a regular court and really interact with the patient, with the people, ask, inquire. And it's kind of a part of how we operate because we begin with a psychiatric examination. So obviously, the psychiatric examination is not an adversarial event at all. And actually, the lawyers are present, but they're not supposed to say a word at this point, because really, even if I'm just talking to the patient, it's really of examination kind of elements to it. Psychiatrists are listening, we can see the affect, we can see how people react, we can see a lot of things by just having a regular, let's say, legal talk with them. So it's really hard to distinguish the medical part and the legal part in this kind of settings, and we're really one group working kind of together. Now, we abide by the administrative law principles, which means that we have the duty to provide argumentation as to why we made decisions we made. For instance, if we think that the patient is psychotic, we should provide with some information as to why, right? And if we think that they are a risk to self or others, we should provide an indication as to how we reach that conclusion, right? And if we think that there is no better alternative than hospitalization, we should maybe explain why, and so on, okay? And if we don't do that, really, how could the district court discuss whether or not we made the proper decision, right? If you're a judicial body, you have to explain yourself. Mostly we review civil commitment orders. So most of the cases that we see are really the civil cases, but we also serve as a body that discusses the decisions of criminal cases, criminal commitment. So we do the review, the timely reviews of people who have been hospitalized after having committed a criminal offense, and the court decided that they should be hospitalized. We will make decisions regarding their vacations, their release at some point, and so on. I will not focus on that today, although it is important and relevant. And as one of our judges said, the Judge Berliner, the soul or the mind is the same mind. There isn't one criminal mind and one civil mind. So to some extent, he is correct, but I would put that aside and focus on the civil cases, which are the majority of the cases. Now, so we hear patients, we meet families, we get heteroanamnesis, we hear about some of the things that happened before hospitalization, we meet with physicians and other experts. And just to give you a sense of what happens, we see about 15 cases a day, which means 15 patients, okay? Just the other day, I had 20 patients one day. So even if you really want to pay a lot of attention, average time cannot be that long. And on average, it is at 31 minutes per patient, which means including everything, including reading the material, talking and having a talk with the patient, sometimes with other stakeholders, with family members, writing, handing down the decision, all of that in 31 minutes, right? And obviously, some cases are very short. If, for instance, for some reason, we're unable to meet with the patient, they're completely sedative or whatnot. So these would be the 2 minutes cases, and others would be an hour and a half. It would be the first time being hospitalized, or other reasons why it's really important to have a more deep and meaningful discussion about that patient. But it's important to know that we have those time restraints, and these are not insignificant. So one thing maybe to consider that seems to affect everything when we talk about this issue, not just in Israel, but in other places as well, is the revolving door phenomena. Steve, I see that you're raising your hand. Is it something that you would like to currently say, or if so, just write it down in the chat?
I apologize. That's just for when you're done. Sorry.
Okay. So we have the revolving door phenomena, and people know that from criminal justice in general, and it's also very common when we talk about the psychiatric services in different countries. Specifically, we're talking about the readmittance rate. So on average, about 20% of psychiatric patients who are hospitalized in Israel, I'm talking about both voluntary and involuntary commitment. And it is important to know that the majority of the commitments to hospitals in psychiatry in Israel are voluntary. So about 66% commit themselves. They're not involuntary hospitalized. So 20% of those people who are hospitalized and are discharged will be readmitted within 1 month, 30 days. Okay, that's one thing to consider. And 40% will be readmitted within about half a year, so 180 days. And it relates to different reasons, but obviously this is something that we should think about, and I'm going to mention it later why it is relevant. Also, it may be that part of the reason people are readmitted so quickly is lack of support in the community. So only about 25% of those who are receiving mental disability pension, and we have about 111,000 people receiving such a pension, which does not include all those that maybe should receive this pension, but a lot of them are not known to the system. Others just don't want to get the pension. They're against being acknowledged as having a disability. So, but out of those who do receive the disability, receive the pension, only a quarter use some kind of rehabilitation services that they might have the right to use. Now, there are different reasons for that. Part of that is that not everybody with a pension deserves it, only if they have at least 40% of disability. Another reason would be that they might got it in the past and then they got into a fight, or they brought a lot of men, or they dealt with prostitution or used drugs in the hospital and were thrown out, and then they need to receive, to apply again to receive this support. So, it's a big problem, but a lot of people don't have support in the community. That's maybe one of the stronger reasons why the revolving door phenomena is quite common, not just in Israel, but in Israel as well. Another thing to consider is really the overcrowding and the shortage of staff in hospitals. So, for instance, you could see this is the crowding, or the measurement of capacity in different psychiatric hospitals in Israel. It's published daily by the Ministry of Health, so that people would know, what's the condition where. You could see that in many of the hospitals, it's close to 100%. In some, it's 120% or 112%. And you could imagine that the quality of staying in a hospital where there is such a high occupancy is reducing, right? It's just not as pleasant. It might have induced violence and other things. Also, there is really a shortage of staff, to be honest. For instance, in one of the hospitals, I'm going to talk about that later, they brought in a social worker from pension, she was already retired, to help them out. And she's trying to do her best to help, but just the other day I met with her wondering why she's not offering alternatives in the community, and she just did not know about those alternatives. She came back 2 hours later saying, oh wow, this is like a new thing, that's wonderful. So in a way, we are working in a mental health system that has a lot of good people, but not enough of them, in conditions that are very, very hard. And therefore, you have to take all that in mind when I talk about therapeutic jurisprudence. These are some of the limitations of what I'm suggesting that we should do. So let me talk about TJ in a nutshell. So we have David Wexler here, so he's probably can explain that so much better than I can. But here's my take on that. So basically, therapeutic jurisprudence that was, I guess, initially developed and kind of became known to the world by the work of Bruce Winnick and David Wexler more than 20 years ago, and is so relevant today, talks about being aware that there are possible therapeutic, but also anti-therapeutic consequences to how we behave in the legal process. So the mere meeting with the judge or with the lawyer could be very helpful and could be detrimental without even talking about the final results of the case. Now, if we prefer the law to be a therapeutic agent, then there are certain things that we may be able to do to reach that. And so the question is, when I think that when it is relevant, we should consider integrate the concept of therapeutic jurisprudence to the law itself. So it would consider how to reduce the anti-therapeutic consequences of the law, but also to the work of the lawyers and also to those sitting in court, including the psychiatric committees. And we can do that by the way we behave, but also by the way we interpret the law that we have to abide by. So we only answer to the law, but we can interpret it in a way that is beneficial and promotes, I'd say, therapeutic consequences if possible. It does not mean that if you have therapeutic goals, all the other things are not important. So there is pushback, as I mentioned in the email I sent some of you, to even using the term therapeutic jurisprudence by some people presiding in those committees saying, well, you're not a therapist, so don't talk about therapeutic goals. And I'm saying the fact that you abide by the law and you have the goals of the law that are not necessarily therapy, that does not mean that you cannot promote therapeutic goals, but not at any price. Some things you would say, well, it would be better for the patient to remain in hospital, but there are other things to consider, like their liberty and other things, so you can't just do it because you want everybody to be healthy. And there are other things like looking at the root cause. So if somebody's been hospitalized lately, we can look at what brought them to hospitalization. But if we look at a bigger picture, then that might be helpful in understanding how to avoid maybe their next hospitalization, to reduce the revolving door. And a lot of times that could be done in collaboration with that person, their lawyer, and other stakeholders. And that's basically what I think is important. Now, I want to move to examples because really, instead of talking about what TJ is, maybe let me talk about how it could be applied in the committees, in the district psychiatric committees. So, you know, when we talk about voice and validation and voluntary participation, the 3 V's, let me give you some examples. So, you know, the concept is allowing the patient's voice to be heard, or the person in the legal proceeding when they feel that they're heard and listened to, that would create a sense of validation. So they are participating more willingly because they're seen. They're not, we don't just talk about above their head. So, you know, the other day, really yesterday, I met a patient and we thought he was catatonic. That's what the department wrote to us, but it wasn't clear whether this was catatonia or maybe due to a head injury they had and so on. And so, you know, so I talked to the patient and I said to him, you know, look, he was in a wheelchair, not moving. And I told him, look, I understand that you're not talking, but I would assume that you can understand me. And I want to explain to you where you are and what we're doing here and what we're discussing. And can you try to tell me, just if you can nod or symbol to me in some way, can you understand what I'm saying and so on? And at first, the doctors next to me thought I'm wasting the time because they see he's catatonic. Let's not waste our time. We understand that he has to remain in hospitalization in his current condition. Why waste the time of the committee? We know he's catatonic. We know we cannot send him somewhere else at this point in time. But I thought it's not a waste of time. I talked to him for 2 minutes. And at some point, he responded with his eyes. He moved really very little. And at this point, the doctors kind of woke up and one of them came to check him physically to see his reflexes and so on. And then the other doctor said, can you reach your hand to your nose and so on? And they realized he understands everything, but he's not talking. And then I got to tell him, look, the doctors here would like to help you retain, get back your ability to talk and so on. And would you agree to be helped? Do you agree to stay here and so on? And he nodded a bit with his eyes, yes. Now, this for me is the voice of the patient. The voice is really not, hearing the voice, but that was so important for me, so meaningful. And while legally we could have made the decision without that, I think that having the remembering, maybe when he's out of this catatonic state, remembering that we gave him his voice when he was unable to talk, I think that's a big deal, right? So that's just, one example. And the same would be to people with slurred speech or dysautonomic speech, when sometimes I would ask them to write down what they want to say and so on. These are things that are important symbolically and not just to gather evidence and so on. And I think that it's really something to remember. We had a young girl, woman, 19 years old. I thought she was scared. And so I asked I asked people to go out of the room with her permission, so there would be less people, so she would feel more comfortable. And then I asked her if she's willing to share what it is that she wanted to share. At some point, she wrote down on a piece of paper the word rape, which was relevant to some extent. And although it's not a content we needed to discuss in length in our committee, it was something to supply the ward and the department this information for the first time, so for them to work on and so on. And these are just small examples. So having your voice heard is important. Of course, having your version of the things and what bothers you and so on. There are other things, maybe smaller things, maybe, sometimes when you have the negativist patients, as my colleagues call it, right? The one who doesn't talk for different reasons. So, going into the ward, meeting them there, so they don't want to come and visit us, we can say, well, they don't want to come, it's their right, we don't force them. But we can come and visit them in the department. Sometimes it makes the difference. Or we can talk to them outside if they're allowed in the hospital to walk outside. And we've done that several times, and we reached serious agreements with patients. So, if I put my ego aside and say, no, I'm not willing to meet anyone outside of the respectable room, then I really don't think I'm thinking about the patient. So these are just small examples of working hard to get the voice of the patient, heard. And sometimes it's really, somebody wants to share their arts, their music, their whatever they painted, tell a joke. It might seem like a waste of time, but a lot of times it opens them up, and then they would share the things that you really need to get from them in a way. And sometimes when they tell you, look, I have a video, a YouTube channel, whatever, and I'm going to promise them I'm going to look at it later. And I always keep this promise. And sometimes it sheds light on information they would not get from them. For instance, seeing how they looked just a few weeks ago when they were not psychotic or not under the influence. So really, it's really amazing what happens when you listen, when you allow their voice to be heard. So that's just one example, right? So how do you reduce possible negative implications of the proceedings? It could be how in prior committees they felt attacked or not heard or whatever, and kind of provides them with a kind of correction to that feeling. Not just the patients, also the families, something saying, thank you for respecting us. Thank you for listening to us. So, I think it's really important because those family members, they will stay there after the person is outside of the hospitalization. They could be a support system for that person. They could give up on that person, and so I think it's really, really important to try to reduce the negative implications. If people are waiting for hours to meet with us, I would apologize. I would acknowledge the hardships that they're going. These are things that are very important. Otherwise, they would really start to lose their energy, and the price to be paid will be that of the patient. Okay, so these are just some examples. As I told you, after seeing so many cases, it's kind of hard to focus on one example, but I do feel that the examples are really important to explain why this concept of TJ is more than just a brilliant theoretical concept. It's something that has to be applied. I'm showing you my version of that. I'm sure there are many, many other versions to do that. So, what else? Sometimes therapeutic contracts, it's a term, or behavioral contracts. So for instance, look, so, you haven't been eating and you haven't been washing yourself. How about you want to be released now? How about I'm going to be here next week. I see I have a committee next week. How about we have an agreement between us? We're going to look at what happens in the nursing report and see if you were collaborating, if you were eating and so on. And then we'll talk. Maybe you could, ask them to transfer you to the open ward. Maybe it will be time to consider alternatives in the community. And in this way, it seems like negotiating, but it's really kind of a shared responsibility of the patient and yourself. And while their doctors could do that, or their caregivers could do that, sometimes the epistemic authority of the judicial body actually allows you to do that in a meaningful way. And so I guess why not, as long as it goes in line with the treatment plan and not interferes with it and so on. Another thing of relevance I would say is about the presence of others in the room. So for instance, if I think that interviewing the patient when their family members are around, or the other way around, talking to the parents or whatever when the patient is there could kind of harm their future relationship, then I would not allow that, right? And so really it depends on the situation. Their lawyer will always be there to protect their rights and so on. But also I would urge the lawyer, look, if we heard the father saying some things, please do not repeat those things when you argue in front of us at the end of the day, because we heard the things, we will consider them. If you have argumentations that need to specifically refer to what the parents said, do it not in front of the patient, because we don't really want a patient who's already with paranoid thoughts about their family and maybe with a history of violence to hear something that would become a trigger to attacking their parents when they're out or whatever, right? So this is another anti-therapeutic thing that can happen just being a part of this procedure, and we can reduce that. We have the legal authority kind of to do that. Now, obviously, empathy is important. Why is it important? There is some work, I can send you the reference, talking about one of the problems in psychiatry and in neurology a lot of times would be anosognosis, not being aware of one's illness or condition. Now, anosognosis could be cognitively not being aware, but also maybe more importantly sometimes affectively not being able to accept that you actually have a problem. And there is some claim that when you talk with the patient about their illness, but you do it in a way that they feel the empathy, then they have some emotions kind of operated, and their ability to accept this and to kind of maybe make a change in their approach towards the possibility of actually being ill is bigger. So I'm going to send you that, because this is really not my field of neurobiology and so on, behavioral sciences. But I do think that sometimes I would actually ask the patient, do you think that we care? I would sometimes ask that, especially if I know that we're going to make a decision that they're not happy with. And a lot of times they would say, yes, I actually do. And I think it's really important, not because I want them to say, yes, you care, and I'm going to be happy about it, because I think they won't say that if they really feel that they're not seen. So that's one thing. I think also empathy might improve compliance, because if somebody cares about me, maybe I could care about myself. And while you can say, well, you see them for half an hour, so why is that important? But yeah, maybe it is important. Maybe it does make a difference. Also, it's really important to encourage the families, to let them know, look, I've seen parents, it was, let's say, a religious figure, a rabbi, who stayed in his car on Saturday to be close to his son so he could visit him during Shabbat, during the holy day, because he was hospitalized for the first time, or was hospitalized and he didn't want them to be alone. I thought that was amazing. Or another father flying, not just fathers, but this is the case in this example, flying all the way from the US to be there for his son who was hospitalized. And I said, look, it's not every day that we see such kind of devotion and being, caring about your son and so on. And I want to tell you that's wonderful. It's really important. And I think people are going through so much, not just the patients, a lot of times their families. And I think it's important that when they meet the judges and those who make the decisions, they also feel that people see what they're going through, not just inquire them about what happened factually and so on. These are just, some examples. I want to kind of almost go to the end of my talk to allow some time for discussion. So sometimes I would discuss the revolving door phenomena with the patient, telling them, look, this is the first time you've been hospitalized. Now, we really want to hope that this might be your first and last time. So the following things are really important to reduce the chances that you will need to, stay here. We need to understand why you're here. Is it the beginning of an illness? Is it just due to drugs or something else? This is, talk to your doctors about it and so on. And sometimes it will make them agree to stay. A lot of times it would. So actually, many times we get the patients to agree to stay. So they're in this strange condition of being compulsory hospitalized, but at the same time, it's really not against their will. And I think it's good to start with that. And at some point when they're better enough, actually really stop the involuntary status and move to a voluntary status. So all this gradual thing has to start, I think, at the committee. Is something they need to have in their mind all the time. We're talking about rehabilitating you. Let's talk about rehabilitation of abilities, rehabilitation of the elements of one's autonomy, as I will try to briefly talk about, and so on. So that's one more thing. I think sometimes we get the social workers involved. We actually ask them, we order them to write a report about what are the possibilities in the community. We do that because sometimes they fail to do that, maybe because of lack of resources or other reasons. And in some cases, it makes a difference. In some cases, it leads to decision-making and finding alternatives to the patients outside of hospitalization, especially with long-term patients. Sometimes there's fights about who's going to take care of them. Do they belong to the Ministry of Health? Do they belong to the Ministry of Welfare? Because there might be cognitive impairment, what we used to call mental retardation, but also, let's say, the use of drugs and also potentially old age. And it's like everybody's fighting who's in charge of the patient, but, it seems like they stay in hospitalization just because there's like technical reasons or bureaucratic reasons not to find them with a solution. Also, there isn't enough room in most of places to patients who need those places. And sometimes it's really hard to know which is the best place for a patient, to be honest. Okay, now, so what else? Yeah, so sometimes there are a lot of legal issues that are important. For instance, there is a fear that the patient is being maybe used by others. Maybe others are maybe using them for sex, stealing their money, trying to get hold of their property and so on. And I would ask the patient, perhaps you would like to have a guardian or somebody to help you. And sometimes they say, yeah, maybe it's a good idea. And so I would write to the relevant department in the legal aid and ask them to help the patient. And that, we've done that several times. Or maybe we will invite their guardians, if they have guardians, to understand what they're doing and try to sometimes even be harsh with the guardian, saying, well, why haven't you done it? The person has been here for 10 years. It's very rare, but that also happens. Why don't you take care of them here? They don't want to leave the hospital for different reasons. They think it's dangerous outside and so on. And this psychosis is not ending and so on. But at least in the hospital, you can get them a lot of things. You can buy them things and so on. Why don't you do that? Oh, I can do that. Yes, you can do that. Okay. So while it's not our role to be in charge of guardians, when we see something that the patient needs and it seems that nothing is done or not enough is done, we would either invite people, even we have the legal authority to subpoena and so on. We don't do that often, but we can subpoena people, we can find them, we can even send them for up to 2 years in prison. I think it was never done, okay? But I do think that in extreme cases, we have to use our legal authority for the purposes of making things moving for the patient. Also, we have to remember sometimes it may be better to write kind of a minority decision and a majority decision, get it appealed to the district court that has more authority than we have, and they would get the people involved, the relevant stakeholders involved. So there are many ways to do it, even without having the formal authority. if you really care and you see something completely not okay in a specific case. And there's also the informal way is calling the head of the hospital or going to his room saying, look, I saw this is a big problem. And he tells me, thank you for turning this to my attention. Thank you for talking to me instead of just writing a decision and waiting for somebody to read it. So like, I try not to be so formalistic, because TJ is not just about being kind to the patient or to the lawyers. There are hardworking people in the hospital working so hard in a sometimes almost impossible mission, and we have to acknowledge that as well. And so this is really why it's a really big issue, of course. So just to let you know that some of our courts have already accepted this notion of therapeutic jurisprudence. So for instance, Justice Berliner from the District Court in Haifa, whom I was his trainee more than 20 years ago, and he was until recently working as a judge even after retirement in this kind of cases of appeals. So honestly, after he took part in our seminar at the university for several years, he accepted the notion of TJ and even implemented it in some of his decisions, saying that the role of the committee is not limited just to a formal decision. It should serve as the eastern wall for the patient, allowing them to express their hardships, their claims, their requests in detail, while listening attentively and with empathy to the patient. In this way, the procedure in the committee will not only have a legal value, but in addition, a psychotherapeutic value of its own. And the Supreme Court in another case actually talks about saying that it was about ECT, whether or not to give ECT to a patient, although we are allowed, according to the law, to provide ECT to a person involuntarily hospitalized, even without their consent, but it's a big legal issue because of, let's say, public response and so on. So the Supreme Court says we saw no reason to interfere with the nature of the treatment provided, a matter left to the discretion of the District Psychiatric Committee and the treating staff. And in all honesty, I don't think that we are the ones making decisions about the treatment. I don't think so. But in rare cases, for instance, the other day, we saw a patient, they're writing to us that the extent of her psychosis and delusions remained the same, remained steady for the past 3 months since she was hospitalized. And I asked my fellow psychiatrists, what do you think about that? They said, well, how about they change the medication, try something else? So we can write a recommendation to consider. We're not telling them what to do, or if it's clearly a patient that could react to ECT well, to just ask them, maybe you can consider the following. We could do it in our decision as a recommendation, or we could do it by just calling them or asking them if they tried it, right? So it's not everything is formal. Really, the important thing is about getting the patient the best, that they can get. So what are the risks of using TJ? What pushback can we have from the hospitals? They may feel that we're stepping into their discretion. We're kind of interfering with what they're doing. So you might have 2 very experienced psychiatrists in the committee, but still they meet the patient for maybe 5 minutes or 30 minutes. Could they really have a better second opinion to offer than the hospital? They might not. That's why we have to be careful and to be maybe a bit timid about what you say, but it doesn't mean you can't express your thoughts, right? The hospital will consider what to do. And then maybe extra work. I'm asking them to write reports. I'm asking them to check a lot of things. They're kind of collapsing under the current burden, so maybe it's too much. And I would say, if I ask them to do it in 3 days, then I make no sense to write the social report. But if I give them 3 months or a month, then it makes sense. And the other day when I met the social worker, it was yesterday, it was after I told them in the decision that she has to come to the committee, because 4 days before that, I was in a committee where I saw that for 3.5 months, they did nothing. And I got upset and I said, well, she has to come. And she came. And then I talked to her and I realized that she has some things that she needs to learn about the system, which I told you about before. So I'm not saying that I know more than the social workers. It's not the case, not me and not the fellow members. But in some cases, it's neglectfulness. It's just people falling between the chairs, as we say, or maybe it's lack of availability of information or any other reason. It doesn't matter. I don't need to blame anyone. That's not the case. We just need to find solutions for the patients, okay? So the risks are maybe waste of time and manpower because they need to have somebody escorting the patients. So they're like, who's going to escort them? And who's going to be in charge if the patient does something and runs away? Is it going to be the nursing staff? Is it going to be somebody else? These are technical matters. What could be the benefits? I think increased compliance. I really do. I really think that we get that more. I think reduced agitation. I had a patient coming to the committee. He was very, very agitated. I started talking to him. I don't remember about what. I think he was doing tricks or he was doing sports or whatever. And I got excited about what he does. He told me something about that. He was completely relaxed. He was really, really strong, obviously. He was very much relaxed. And we talked and so on. And we ended as friends and he agreed to stay. And the psychiatrist tell me, I was sure we will have to give him an injection before he leaves the room because I was sure he's going to, lose it. So again, why? I don't know, just empathy, being a bit interested. I'm not saying it works all the time. I'm not going to say that. There were some scary elements in the committees that I chair, but usually, really, it makes the difference. And I think very importantly, promote willingness to participate in rehabilitation and receive support in the hospital, think about the future, and really building a plan and kind of all the time talk about that. Some patients change their minds. Some of them join these rehabilitation programs. They agreed to stay to make this all ready so they could move from door to door instead of leaving the hospital and then a week later be found, in the streets after using drugs and whatever, because they got nowhere to go really to kind of take care of them from deteriorating. Okay, so I talked about the pushback saying the judge will not treat and the caregiver will not judge. And our friends said that it should be just humane jurisprudence, but not therapeutic. And I say, you know what? You don't want to call it therapeutic, don't call it therapeutic. We can call it health promoting jurisprudence, but the concept remains and it's important. And these are my friends, not to be mistaken, but we just do not agree on that. I don't think one needs to be scared of using the word therapeutic. We're not doing psychotherapy. That's not exactly what we do. But there could be a sense of improvement also. We are just agents. Being a psychotherapeutic agent doesn't mean being a psychotherapist. Now, just to end this, you probably know the distinction of negative and positive liberty. So we can say that when we take away the negative liberty by hospitalizing a person, we may be doing that in order to restore their positive liberty, their ability to achieve their goals, because the cancer patient that I met who was not going for treatments because he thought she was cursed by his sisters and really it's not a matter of the doctors to solve. She did not want to die. She just wanted to get it treated in the proper way, which relates to, being cursed and not being with an illness. Now, having her negative liberty stripped away from her, agreeing to hospitalize her, which was not an easy decision. So I thought, is this immediate danger? Is this a non-immediate danger? And so on. But I said, we're doing that in the hope of allowing her to restore some of her functions and capacities in order to make an informed decisions whether or not she wants to fight against her cancer or not. Now, and in this specific case, I was happy to hear a month later that she was released about a month later, but her family was now all around her, supporting her, fighting to release her from the psychiatric hospitalization and to get her for treatment, and she started going to treatment. Whereas when she just arrived into the hospital, her family was kind of hostile. It was really hard to get any information from them, okay? And I suggest that you look at how Rebecca Kukla talks about autonomy, specifically positive autonomy, because she talks about different elements of autonomy. The way I see TJ, we are supporting a gradual recovery and rehabilitation of one's autonomy functions. You want to talk about ego functions? That's you, because you're a psychotherapist. But I know about autonomy as a philosophical concept. So self-determination, the ability to choose, and the possibilities. So we provide possibilities. The things that we can provide during hospitalization, Do you want, like the things that we can ask the patient to make decisions on that are not necessarily about being released or not. You want to move to the elderly department, but also you want to go to the open ward. Let's make just one decision at a time. So which one of them do you prefer? We don't want to make too many changes at the same time. This is the kind of things we'll do. Integrity, being kind of in consistency with your regular life. Yesterday, I talked to a patient. In her psychotic state, she thought that her father is raping her every night. He's not just raping her every night. He's murdering her, and then he's raping her, and then he resurrects her, okay? And there are other things. And I talked to the father. She's been there for more than 2 months. And the father is saying, look, I went to the police for 6 days because of that, and she thinks that I'm raping her, her mother is raping her, her sister is raping her. We haven't seen her in a month. I said, have you given up on your daughter? He says, no. Well, how about some of you visit her at the hospital so she has some connection to her former life? Of course, that has to be done in connection with the therapist in the hospital, so it's not, bad for her. But that was after I asked her, would you like to meet your family? Would you like them to visit you? She said, of course, I don't want to burden them, but yes. So it's not, autonomy is not just about being released. If you get gradually the habits, meeting your family, a sense of continuity, a sense of independence, a sense of agency. All these are elements of autonomy that could be gradually restored in the hospital, and the committee can be a part of doing that. So it's not just a philosophical concept, and I relate to that in many of the decisions, how we're not just stripping away of the negative liberty, but kind of trying to restore the positive one.
Okay, Oren, I have to tell you, we're out of time at this moment. So two things. One is this is being recorded, and so in theory, people could get this from, I guess, our website. But it's very exciting stuff. I'll be able to call on maybe 1 or 2 people. The point, of course, is you could say that since therapeutic jurisprudence is a kind of oxymoron, referring to 2 totally different realms of discourse, your challenge is to keep it from being that. In other words, to not make the therapy exclude the jurisprudence and vice versa. Keeping it quick, people. Steve.
Very quick. Love your presentation, Oren. I love therapeutic jurisprudence. I just wanted to say quickly, I've been contacted by a woman who is in the QAnon hole, involuntarily committed, medicated, no understanding at all about undue influence. And I'm interviewing this Harvard psychiatrist, very important book talking about the impact of the internet. And young people are spending 11 hours a day, elderly people 6 hours a day, and a lot of delusions, a lot of psychotic things going on, but it's not from organic psychopathology. So really interviewing the families first to see if there's been a radicalization. And I love your work. Thanks.
Thank you.
Okay, Joyce, very quickly.
Unmute yourself.
Okay, Joyce, while you're figuring out how to unmute, let me call on Neely, who is a guest from outside, and see what your comments and thoughts are.
Hi, Oren. Thank you for the great presentation. I was wondering how common your approach is among other DPC chairs, since you mentioned pushback.
Good question. I haven't done a poll, but I could say that there is one more vocal chair who wrote a paper about that, is my good friend and colleague, Dr. Wolfman. So I know he is against it. And some I know that don't think they support it. But in all honesty, if I read Wolfman's decision, also and how he does things, in a way, he does most of what I'm talking about. He just doesn't agree with the term. So again, I don't care how you call it. You can call it Moses, as long as you do it.
Okay, great. Joyce, have you unmuted yet?
I believe I have. You hear me?
Yeah. Yeah.
Okay. A number of the factors that were mentioned that were going on in Israel in terms of increased revolving door, decreased time for meeting with patients, shortage of staff, the negative, what I call negative freedom, the idea of moving from negative freedom to positive freedom, with the patient realizing that and eventually agreeing to stay, but not being available because the time spent is less, the staff are fewer, and they are, I'm wondering, they're also discharged more prematurely. He mentioned a lack of community to discharge to, which we also are experiencing with lack of insurance. They're being discharged to the streets. All of this incredibly similar, it seemed to me, to the United States. Does he agree with that, and what he's seeing in the United States?
Well, I don't think I should talk much about the US, but yes, it's not just in the United States. Actually, I've been participating in a Brazilian meeting, so I could say they have even more problems that other countries don't. So yeah, these are similar things. Maybe the data is not the same exactly, but the rates are similar. The rates of people with illness and the rates of people in revolving door phenomena. It's similar.
Okay.
Yeah.
Are you also having an increase in suicide rate, which we're finding in between 18 and 35-year-olds? It's gone up to be the second rate of death in the United States.
I don't know the answer to that, but also I'm not saying there is an increase in the revolving door. I'm just saying this is the phenomena. It's been steady over the years. It's not an increase. It's steady.
Okay. Tyler, take a moment to think about what one concept you want to get across in 30 seconds, because we're at the overtime.
Very, very simple. I think it's a marvelous presentation. It encapsulates all the details, encapsulate what happened when we collapsed all those functions as we moved from institutionalization to deinstitutionalization. A lot of the things that you talk about there were things that were given separate roles. Now, and all around the world, the problem's the same. How do you do those different things and talk across disciplines to provide them? We don't see the same kind of illnesses and conditions we used to. They simply don't exist like that. I haven't seen a case of catatonia, and I can't remember when.
Right. Right. You don't get to stay catatonic long in the modern era. First, let us signal our approval of Oren in the traditional PIPATL manner. And thank you, Oren. A really striking, a wonderfully cross-cultural thing to occur. All right. The other thing is that there's always unintended consequences. The program in Psychiatry and Law did the only study in history of how judges make the commitment decision during the commitment decision. And it turned out that the only moving factor was the judge's opinion that the patient would be a good outpatient. Dangerousness, who cares?
Right.
Committability, who cares?
There's just one thing I wanted to ask, if David, if your voice works, is there anything you want to share with us, maybe even shortly, being kind of the father of TJ, that I'm so happy that you joined us. Are you able to unmute?
Yeah, you have to hit the little microphone in the bottom left corner, Dave.
Now I got it?
Yep.
Okay. Well, I thought this was wonderful, 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 wonderful. And I have millions of comments, but I don't know where to begin. I think therapeutic jurisprudence has always been a problematic term. It used to be, it was originally proposed by me as something worse than that, something like juridical psychotherapy or something like that, and the person at the hearing at that thing couldn't even pronounce juridical, was saying juridical. People said, you got to drop this name. I said, well, the first runner-up is still a mouthful, but it's therapeutic jurisprudence. If you don't like it, call it TJ and give it little nicknames. But it really, one of the things I'd say, Oren was saying, well, call it this, call it this, call it this. I really think it should be called TJ, therapeutic jurisprudence, and then say hereinafter TJ, because all the literature is out on that, everything. And one of the things that's so important is that we need to be a community and learn from each other. And all of the things that Oren gave as examples for you may now be thinking about and using, but that needs to be be beyond that. We need to really, really do that. And the resources are all under the name Therapeutic Jurisprudence. And I can do lots of stuff about that if anyone wants to know about it. But so many things of how important the family is. Sometimes families, if they feel that no one's being listened to, they will just decide we're not going to do this next time. So they won't be back if the hearing was considered a farce and no one was allowed to talk or whatever, even if they may be have the same position as everyone else does about commitment and all
David,
that.
in concept of not being allowed to talk, I got to stop you because we're deep over town. However, what I understand from both your and Oren's content is that there's certainly room for another follow-up meeting on this topic. And I'm wondering if we do that, would you be free to join us?
Please.
No, I would certainly try to, and sure. And I know Michael Perlin is real interested in this, and others.
Yes.
So I think we can. Let me just give
And
you an email.
Michael's away now, so but it's future. He may be back, and then we can get many of the same crew together and explore this in more detail.
If anyone wants to be in touch with me, I would just like to give the email, David B. The B's important. David B. Wexler at yahoo.com. I can send references, do all sorts of stuff, and keep in touch that way. But I thought this was wonderful.
Right. I'll send it to the listserv so everybody would have it.
That'd be great.
Thank
All
you.
right. Thank you. See you next time.
Thank you. Bye-bye.